We can go ahead and get started. Let's call it. Okay. Good morning. This is Judge Alyssa Perez presiding over the 210th District Court criminal docket. Well, no criminal docket, new case old case set for or quick turnaround for December 3rd, 2021. All matters being heard today are being heard in accordance with all emergency orders and directives regarding COVID-19. In addition to that, we are streaming all matters live via YouTube. I've explained to the parties that I am remotely working and having a terrible connection. So I apologize for not being able to turn on my video. I just want to make sure I can hear everybody okay. It would also mean I do not have access to Odyssey. So please let me know if you need to refer to things that you just explained them to me. All right, Mr. Pantoja, would you call our case, please?
Yes, Judge. It's cause number 2021-020-2380, State of Texas versus Clevy Nelson. Announcement of counsel, please.
Michelle Hill, Haban Muhammad, and John Briggs on behalf of the state. The state is ready to proceed, Your Honor.
Brock Benjamin on behalf of Ms. Nelson, and based upon the time constraints and essentially the closeness to trial, Your Honor, I guess it's the same thing as time constraints. I spoke with my client and I have permission to proceed without and waive her presence, Your Honor.
Okay, and there were a couple of things just to give some context here. My understanding was the state had requested a very quick hearing on the state's second motion for continuance. I'm unaware if there's another motion that needs to be addressed. And so with your permission, Mr. Benjamin, we were able to schedule it for this morning. Ms. Hill, are there any other motions that you're asking the court to consider today?
No, Your Honor, just the state's motion for continuance. And
Okay.
the prior motion, I believe, was filed by previous counsel from the state prior to it being reindicted. That's my understanding.
When was it
That's why
reindicted?
it was reindicted.
September 28th, if I'm not mistaken, plus or minus a couple of days, Your Honor.
I'm sorry,
That
could you
sounds
say
about
that
right.
again, Mr. Benjamin?
I'm trying to pull it up.
End of September, I think it's September 28th, but I
okay.
could be off by a day or two, Your Honor.
Okay. And it is the state's second motion for continuance, correct?
Yes.
Yes, Judge.
Yeah.
It's our second motion.
When was the first one? Do you know the date?
It was essentially September 27th, if I'm not mistaken, Your Honor. It was
And it was-
filed.
Mhm.
It was filed right before the reindictment, and that was before the October 14th trial setting.
And was that the sole reason for that continuance?
Judge, if I'm not mistaken, in the state's first motion for continuance, we were asking for more time to locate some witnesses who had moved out of state. And I don't remember what the change was in the indictment, but I do recall that the first motion for continuance was to locate some witnesses.
Are they the same witnesses that are listed in the second motion?
They are, Judge. It's what's happened is all of these parties, well, the parties, the defendant, the victim, many of our witnesses were all in the Army. And after the offense, what's happened is almost all of them now have separated from the Army, either left voluntarily or involuntarily. And we couldn't find them because they had gone back to, wherever they were from, around the United States. And I think that was the reason for the first continuance, was to locate those witnesses. And what's happened now, judges, in the interim is we have located them, and we have contacted them. Our investigators contacted them, and to put it very bluntly and very succinctly, they're giving us the finger on coming back for trial. So it's now going to become necessary for us to.
I can't hear.
You can't hear,
Not sure
Michelle?
who that is.
Okay, Michelle is telling me that she can't hear. I can see her on the screen.
Okay.
Perhaps Haban, if you can call her on the phone. But Judge, what's happened is these people have now gone to the far reaches of the United States. We have one in California, one in Georgia. We've contacted them. They've said, we're not coming back for your trial, basically. In fact, one of them has criminal charges pending here, and so he really doesn't want to come back. We're going to be forced now to approach the court for out-of-state subpoenas for these people. And it's not just going to be your everyday kind of out-of-state subpoena. It's going to be the kind where we're going to request that jurisdiction to hold them in custody until we go get them. And then we're going to request that they be held in custody here until the next trial setting if the court is inclined to grant the state's motion. So we have very uncooperative out-of-state witnesses who I can no longer go to the Army and ask the Army just to order them to appear because they've all left the Army.
Okay, but what, in terms of their locations, maybe not so much about knowing where they were in terms of being cooperative or not. Did we know their locations as of the last motion for continuance?
Well, what's happened is since the last motion for continuance, we have located them. We filed that first motion. My understanding was to locate them because they had left the Army and we were having to track them down. And at the court, graciously granted that continuance. And in the interim, what we've been doing is tracking them down. And we have in fact tracked them down. And I believe Ms. Hill, I don't know if it was part of attached to the motion. I just read through the motion. I didn't look to see if there was an affidavit at the back. I know that we asked our investigator to prepare an affidavit with his attempts to locate these witnesses and his communications with them, and that they have indicated to him that they will not cooperate with our prosecution, so that we can approach the court for out-of-state subpoenas where these people will be held.
And Your
I
Honor,
don't,
and I
hold on a second. Michelle, you have a lot of background noise. I don't know what's going on, but I'll tell you this. I don't see that, Mr. Briggs. I just see a generic boilerplate, everything contained is true and correct. And the substance of the motion is that no longer live in El Paso, moved out of state in the process of obtaining a court order. What I want to know specifics on, let's see, there's three witnesses that are listed here. I want to know the specific efforts at contacting them since the last motion for continuance.
Your Honor, if I can speak to, I was having audio problems for some reason. I lost
can hear 'em.
here and I was trying to speak and I don't think you all could hear me. It just looked like I was doing sign language. I do have an affidavit from our investigator, which was prepared on November 24th, specifically stating what he's done to locate these people. With regard to the first witness, it's Alexis Janae Simmons, excuse me. He's relocated. They did, her last known address is 825 Cedar, New Bern, North Carolina. He did attempt to locate through her last known address as well as her phone number. With regard to Donald LeGreg Mathis, he actually spoke with him. This person, his last known address is 341 Henson Avenue, Columbus, Georgia. He is no longer in El Paso. He is relocated and he is no longer in the military. He is available by phone. We will be serving him. And he has unrelated criminal charges also, so there will more than likely be an extradition in addition to a request for an out-of-state subpoena. Additionally, we have Kenneth Morgan Bell, last known address 897 Santa Maria Circle in Duarte, California. Our investigative team was able to make phone contact with him. Also, he is also relocated no longer in El Paso nor in the Fort Bliss area. Final necessary witness was Augustine Serafino. He actually was in El Paso when they spoke to him on November 17th. However, he has also left the military and left El Paso, and his address is 555 Denmark Street, Louisville, Kentucky. He left last Friday. So our investigative team did exercise due diligence in contacting these witnesses. However, as Mr. Briggs has stated, they have relocated and they are no longer with the military.
Okay, and so I don't see, unless the copy I received, I don't see that affidavit from your investigator. And what I'm asking for is dates. I think on the last one, is it Serafino? He's not listed in the motion, is it? Is he?
I don't believe so, but I believe that he left that Friday after the motion was filed. But I can forward to the court as well as all the parties the affidavit via email.
That's fine. I really what I want to see the affidavit, but I want to know the attempts at contact. So for example, you mentioned only one, November 17th, that was that gentleman Serafino. But with respect to Ms. Simmons, Mr. Mathis, and Mr. Bell, I mean, are we talking about in the past week, we've gotten the information on them and now we know they're uncooperative and not in state?
was done the week prior to November 24th.
So the same
So
time period, more or less?
Time frame between that week prior to Thanksgiving, between the 17th to the 24th is when he made all of these attempts. And he reduced them all to writing on the 24th, and that's when we submitted the motion, because that's when the final witnesses and the final attempt, and I had him reduce it all to writing as far as what he has done. And I
Mr.
forward
I'm sorry, Michelle, Chris, I don't know if you're there or someone from the court staff or maybe even Brock. When was the December 9th and 10th trial date set? What was
Your
it at the
Honor,
last?
It was set back when the court continued the October 14th
October
trial
14th.
setting. And that was based of Your Honor, that's the answer to the court's question. And then I'll wait for the court's call on the rest of it.
Okay, that's what I wanted to know. Okay, Ms. Hiller, Mr. Briggs.
And Your Honor, other thing with regard to the motion, and this is information that we obtained subsequent to filing the continuance. We spoke with a major
Subsequent to
group.
file. Hello, can you say that again? Subsequent to filing.
Yes, subsequent to filing, I'm sorry if I was speaking quickly. Subsequent to filing the motion for continuance, the state's second motion for continuance, we received information from Major Bruce Robinson that the defendant, Ms. Nelson, her elimination from the U.S. military, the Army, was approved. So she will be separated from the military. The paperwork had to be processed through Fort Bliss as well as DC. We presented counsel for the defense with a motion for that additional information and extraneous offenses. As part of the discovery process, I anticipate that we will be receiving paperwork from the military that also needs to be provided to counsel for the defense, but we do not have that in our possession yet. I believe the final paperwork will be signed on Monday, and I believe that Ms. Nelson was placed on notice December 1st. So to make the court aware, there are additional discovery paperwork and things that we may come into our possession that we also want to provide to the defense as part of his defense. And as far as the state's case.
Okay. Anything else?
Nothing further from the state, Your Honor, and I will forward the affidavit momentarily to all parties involved.
What are you requesting in terms of a turnaround time for this trial?
Judge, if I can kind of jump in on that real quick. The problem is that the out-of-state subpoenas are, they take longer than they should. We have to contact the jurisdiction. We actually have to contact the county where the witnesses are living, get the assistance of a prosecutor's office there to file a motion in court, to have a summons issued for the witness to appear in front of that court, to have a hearing on our motion for the out-of-state subpoena. And so we have to have time to contact them, have them file their motion, get a setting, get the witness served, get them to that hearing, have them advised by the court that they're going to be placed under subpoena or possibly even taken into custody until El Paso goes and gets them. And I wish I could say that's a quick thing, but I think 30 days at a minimum is the fastest I've ever gotten one of those on the turnaround. So I'd like to say we could get it done in 30 days, but that might be a little optimistic. 45 might be pushing it. I think that within 60 days, if we're going to get them, we will have them. If we don't get them in that time frame, we're probably not going to get them. So I think 60 days, just because of the logistics of having to do all of the out-of-state subpoenas.
Okay. Well, and again, I apologize for all the very basic questions I'm going to ask, but when's the date of offense and when was she indicted?
Judge, I believe the offense was in October of 2020. And so she has been in jail now for a year here at the end of October, November. So about 13 months. So if we were to get 60 days, she will have been in jail for 15 months at that time.
Okay. And that first indictment was when, because I thought I remembered that she was indicted subsequent to the co-actor.
She was indicted the first time on or about November 15th or November 20th of 2020, Your Honor.
2020.
It was in response to a habeas I'd filed.
Okay. All right. Okay. Anything else, Ms. Hill, Mr. Briggs?
No, Judge, not with regard to the continuance.
Okay. Mr. Benjamin?
Your Honor, I apologize. I like and respect two of the three counsel. I don't know Ms. Mohammed. I met her yesterday, but I don't have anything there. But Your Honor, I don't know how to respond to this because the state has tooth and nail, and not the three counsel that are appearing, fought me on bond because they have represented that this defendant is a danger and a flight risk. She is a captain in the United States Army and still is to this day. And we're going to have to take up another issue with the discharge, because if the case goes to trial, the state, I believe, is under a misapprehension that she will be actually formally out. She will not be formally out. And so, but that brings up the issue that I have. On September 28th, after having filed its first continuance and having represented that that Greg Mathis, the witness that's not named in the first continuance, and the witness that's named, one of the three witnesses named in the second continuance, the state represented that he was in custody in Georgia. That was the first time that was disclosed to us, and that was where we're at. I've ordered that transcript. I understand that transcript will be ready next week. My concern is that I keep asking for information about the Army, and what I'm getting from the state is that it's a one-way road. The Army's giving them information. They gave the Army a whole bunch of other information, but when I'm asking about information regarding Mr. Mathis, I'm being told that we don't have control over and we can't get any information out of the Army. And so that's not from this council, Your Honor, that's from prior council.
Yeah, I believe it was Mr. Cox that was handling the case and had represented, and because this was something I anticipated we were going to have a disagreement on regarding Mr. Mathis's, I don't know if it was military history or what it was.
It's all kinds of history, Your Honor. And so, and that leads me into one of the issues I filed as a formal Brady request. And I would ask the court, because normally I serve and I have served, and I outlined in my Brady request the notices that were sent to the state, but I'd ask the court that the court signs a formal order requiring the state to provide Brady information. A large piece of this case is the fact that the decedent in this case has a false report. But I have gotten, and I realize it's not Brady if I know about it. I'm not going down that road, but I haven't gotten any representations that we have conducted a search on the decedent and have found no other information. There are two strippers in this case, and having been around Jaguars and other things, I have a doubt that those two strippers are what I would call clean totally. I've gotten no formal Brady information other than what I have asked for specifically in writing. And so I'd ask the court this morning to consider signing an order ordering that Brady. But with regard to the continuance, Your Honor, Greg Mathis was named and was told that he was in custody on September 28th, I believe. And then now we have a second continuance saying that we have three witnesses. The other two witnesses were never mentioned. And what it appears, and the state has changed out, and we've got new counsel that started right before Thanksgiving. And I appreciate Ms. Hill's courtesy in sending me a draft, unfiled or however it was, copy of the motion before the Thanksgiving holiday. So I had a heads up. But as the court heard right now, we have had phone contact with these people. And actually, I've had contact with Mr. Serafino since November 17th, me being my investigator. These people are reachable. The fact that they are not able to be reached on the eve of trial, appears to be being handled like a DWI case where we're just randomly asking witnesses to appear or show up. This is an individual who has been detained for 14 months, I believe, if my math is correct, but October 11th of 2020 to this date. And so we're ready, Your Honor. I've had a subpoena outstanding for one particular witness that I have been unable to have served in Houston. But at the same time, that's a witness that the subpoena has been on file with this court since the beginning of October, I believe, approximately. But there have been, haven't heard that any subpoenas or any court orders have been issued. We're planning on issue. We're requesting to issue. We're requesting to go forward. We haven't gone forward is what I've heard from the state this morning. And so My issue is that we are here, we're on what I understand is a special jury trial setting according to the docket. We all agreed on this date, and the court, I understood, cleared this. And I understood we're going to be set for and looking at a 1-week trial. And I have 109 witnesses listed in the witness list that provides, and I objected to this. And I don't know if this is the proper time to take that up, Your Honor, but I don't know how to get through 109 witnesses in what was represented as going to be a three-day trial by the state. And so, Your Honor, what is, I believe, most frustrating is the fact that I don't know how many bond hearings this court's given me. I think the number is about 5 or 6. Each time we have approached this, the state has said, we are going forward, we are running, we are ready. This defendant is a danger. This defendant needs to be tried. This defendant needs to be held accountable. Nobody has mentioned the fact that the decedent in this case has a crime of moral turpitude that represents, and they've also blown that off every time I raise that with prior counsel. But yet my client is to be held without bond, or not without bond, on an extremely high bond that she's with an affidavit shown that she can't meet. And now we're at the state's second request for continuance. Your Honor, I think, and I'm happy to address any questions the court has. The court, I believe, knows me well enough to know that I'm fairly adamant, Your Honor. We're ready. We're looking for trial. A offer was made yesterday, formally for the first time. That offer has been communicated to my client. My client is rejecting that offer. I understand we have a plea deadline of Tuesday, Your Honor, but I don't know if there'll be any other offers, but we're not intending on taking that, Your Honor. We're ready for trial on December 9th, 2021.
Okay, so I think I've received, Ms. Hill, a resubmitted motion for continuance. Again, the affidavit attached states the following, and it is by Ms. Mohammed. I am an assistant district attorney. I've read the continuance. All the allegations are true and correct. I don't see anything from an investigator. Is that separate?
Yes, it was a separate sheet.
Your Honor, I received an email that's labeled affidavit witness Nelson, but it's to Michelle Hill from a Esparza, and it outlines, but Your Honor, it's not an affidavit.
Okay, it's not an affidavit? No.
An email, Your Honor.
It's not notarized, Your Honor. This is what he reduced to writing as far as the efforts he has done.
An affidavit. All right. Okay. What else? Anything? Ms. Mohammed, if you're speaking to us, you need to unmute.
Okay, Your Honor, I understand.
If you were addressing the court, I'm sorry.
I didn't want to overspeak you.
Yeah, Mr. Briggs, do you have anything else? I mean, I'm not seeing the attempts at contact, Ms. Hill, whether it's an affidavit or a list, notes, whatever it is, if you'll send it over. I don't see anything. I'm very concerned about, here we are again with transition leading to serious cases being mishandled. Simple as that. I mean, I don't know how, if we were already at a trial setting back in October-ish anyway, trial set October 14th, how your office didn't literally scramble to do the work that you're asking more time to do today. And so on some of these witnesses, at least that last one, I guess he was here up until last week, that'd have been somebody. But I just, I can appreciate how much the states needs these witnesses, but you've had time. You've had time to work your case and get these witnesses here for trial, or ask for the court to assist you. So if you have something else to provide the court, I'm happy to consider it. But for now, the motion for continuance is denied.
Then, Judge, if I can have Ms. Hill send over, I haven't seen exactly what was prepared by the investigator with regard to his attempts, but if I can have her send that over to the court for the court to review.
I'm not sure why that's not going through. Let me resend it.
Okay.
And Brock, have it there, maybe, I don't know, I have been having a lot of technical issues with the internet. I did receive an email still at 9:16, but that is the motion. I haven't received anything since, so.
At 9:55, there's an email to myself, John Briggs, the court, and it's labeled affidavit witness Nelson.
Okay.
And it's what I'm looking at. I would classify as email. It doesn't have any language, any notarization, or anything other than it's an email to Michelle Hill from Esparza.
Is anyone able to share that on the screen?
Yes, Your Honor.
Okay, that would be good. I don't know how to do that, so that
Host
helps.
is, well, Your Honor, the host says disable participant screen sharing.
Ooh.
Let me change that, Judge.
Thank you.
That's probably a good idea.
That's way beyond my pay grade, how to
Okay.
enable.
And I believe I sent it to the court coordinator too, if you want.
Yeah, Michelle, I think, honestly, I think it's my connection here that's preventing me, the same thing that was making me have a bad connection for YouTube.
And Judge, while that's going on, I just want to say that my involvement in this case kind of started yesterday, really.
Mhm.
But I don't want to go through a lengthy discussion of this. The court had set us back in. It sounds like early October. There was an indictment right before that trial date. Before any of the three of us were involved in the case, and then so there's a motion for continuance and an indictment. Okay, that's that troubles me to see that, but I can't do anything about it is what it is. And the court set us for trial probably right after that indictment for this December date. And I agree. At that point, there should have been a lot going on with this case, and people diligently trying to find witnesses and get them served, especially if we learn that they've left the military and now they're spread across the United States and we have to bring them back. I know, though, that Ms. Muhammad and Ms. Hill didn't get dragged into this thing until I believe not that long before we were scheduled to go to a conference out of town in November. So I know that the court believes that right after that last setting, probably in early October, we've had almost October, November. We basically had 2 months that we should have been diligently working on this. And I'm not going to name names or try and discard blame, but my team here only got involved in this case in the middle of November, and we have been diligently working on finding these people. And then it became apparent that they were out of town and not cooperative. And we have been working as hard as we can for the time that we've been on here. And that doesn't change the court's concern. And the court is absolutely right. It should have been diligently handled from the beginning of October, not the middle of November. Judge, you're right. And there's no excuse for that. So, but I just want the court to know that we have been working as diligently as we can on this. And if Mr. Benjamin has not been receiving, responses for requests for information, I think that's improper. And certainly we're happy to see what we can do to address those concerns. And if it's stuff from the military, unfortunately the military can be difficult to deal with, but we can certainly reach out and see what we can do. And for example, this thing with this former Sergeant Mathis guy, who has the criminal charges, just as of yesterday, we were looking through the case. And although I know we had told Mr. Benjamin about his pending charges, it wasn't until yesterday that we got around to linking that criminal offense report to the file so that Mr. Benjamin can see that. So, unfortunately, the three of us have gotten into this very late in the game, and we're doing the best we can to kind of mop it up and get it in a position where it's ready to go. But the fact is, we haven't had the time. So, and I don't mean that as an excuse, Judge, because you're right. This should have been diligently handled at least since the last time you set it for trial.
And Your Honor, with regard, I'm sorry.
Go ahead.
No, just stating, and with regard, Mr. Benjamin, to any of the histories with regard to the military, I have contacted CID. I'm in the process of trying to get all relevant information, and as soon as we have it in our possession, it will be provided to you.
Thank you, ma'am.
I've also spoken. I've had a lengthy communication with Major Robinson, asking him with regard to the protocols, with regard to, if anything having to do with the military, it's above and beyond what would be a normal civilian. However, he is assisting me with the proper protocols and mechanisms in an effort to get these prior histories and everything that you need in preparation for your case, as well as the state. So we are diligently pursuing every effort that we have. And Your Honor, myself and Ms. Muhammad will be handling this case. So point of contact, Mr. Benjamin, will be the two of us. So we don't anticipate any change whatsoever with regard to prosecutors. The homicide team will be handling it.
Let me see. Okay, so I am looking at, it looks like a memo from Mr. Esparza to Ms. Hill, and dated November 24th, states efforts made to locate witnesses. It does identify 4 witnesses. It indicates there's 5 other witnesses located that are available. So I'm assuming they're local. It is lacking some information in terms of actual dates of contact. With respect to Mr. Bell, there's a reference that last known address on 10/16, but that doesn't tell me that the effort to locate him occurred literally after the last setting. And I think we're all, unless this memo changes significantly, I think we all understand what has happened. With respect to these 4, and I don't even know if Mr. Benjamin would be in agreement, but are they able to appear remotely?
I don't believe so, but I don't want to speak to that. I will have my investigator specifically address that question, Your Honor.
Because one of them,
Your
I mean,
Honor,
I don't, go ahead.
Your Honor, respectfully, kicking and screaming, I cannot and will not, and I have taken that position in everything so that nobody can look at me and say that I haven't done that. But Your Honor, the word I have is kicking and screaming.
Okay, so I take that to mean you would object to remote appearance.
Yes, Your Honor.
Okay, I just thought I'd ask.
Judge, I'm pretty confident they could appear remotely. I don't think they will appear remotely.
Okay.
So I don't think Mr. Benjamin has anything to worry about in that respect.
Okay. So if you think you all have some more information, I'll reserve, I'll take back my decision if you want to give me something else before Tuesday, because I think, what I'm seeing with this memo is, again, just nothing that I think is sufficient to warrant a subsequent continuance. It has been a very involved case. And with respect to, I guess, what Mr. Benjamin mentioned on the bond, we've had so many hearings with his client and the bond. And I do recall the, I guess, high concern for her release. And I think I've reduced the bond anyway, right, Brock? We've come down on the bond, but she's still unable to bond
Your Honor,
out.
the court has come down and it cut it in half. And prior to the last consideration, Your Honor, we had put information on the record. But yes, the court has reduced the bond once.
So I don't know what you all want to talk about between now and Tuesday. I'm happy to address this again on Tuesday if the state thinks they have more information that would assist the court maybe come to another decision. What is the rec?
Judge, yesterday I spoke to Mr. Benjamin. It didn't appear that there had been negotiations in the case, although it was related to me that there may have been an offer of 40 years at one point on the murder charge. I'm not sure exactly where that information comes from, but we sat and had a long discussion yesterday within the unit. We even kind of staffed the case with the DA and the first assistant and got some input there. Explained what's going on with the case, things of that nature. And yesterday I communicated a recommendation of 20 years on the second count, which is the manslaughter count, to Mr. Benjamin to relate to his client. So the recommendation was for 20 years on count 2, the manslaughter count.
All right. Okay. Well, I know, Mr. Benjamin, you have a time constraint today. Is that, I think we're probably pushing up on that.
We are, Your Honor. This court has me, and so this court has me.
Okay. So then what else do we need to address? I'll hold off on the continuance, but I operate from a position that unless I hear something different, that continuance is denied.
Your Honor.
Currently,
I'm sorry, Michelle, I didn't hear you.
I wanted to ask what the bond is set at currently.
It's a $250,000 bond, split bond, $125,000 cash. The problem that we have and what we've put in writing in an affidavit is the fact that my client sold property to raise fees for investigation and funds and everything else. And so does not have any property. And so she has raised the funds for the cash, 10% portion of the cash bond. But that's the issue. And Your Honor, and as the court's aware, I will beat my head against that brick wall if for some reason the district attorney's office comes back, or if the court grants the release. I would ask the court to reconsider that.
Okay, aren't we set for a bond hearing on Tuesday, Brock, or no?
Your Honor, I understand we're set for a final pretrial. I think it's labeled final pretrial plea deadline, if I'm not mistaken, Your Honor.
Chris, can you double check that? I thought there had been emails where the last request for a bond was to be set.
You know what, Judge, all I have is that final hearing plea deadline on Tuesday, Judge.
Brock, hadn't you submitted it to us for a hearing?
We did, Your Honor, and then the court had said it was taking it under advisement. I didn't understand that the court was setting it for. The court had said it was taking it under advisement, and so.
But did you email the court asking for a hearing?
We had prior to the last hearing, which I believe was November.
Okay, now here's the point. Set the bond, Chris, for 3 p.m. on Tuesday. I'm assuming that's when our final hearing plea deadline is, or no?
Actually, it's in the morning, Your Honor.
That is correct, Judge. I will set it for the 3 o'clock docket.
I think it's set at 3 o'clock, Brock.
Oh,
yeah.
Okay, sorry guys. Again, I apologize. I'm not looking at Odyssey. Okay, so we'll look at the bond then. What else?
Your Honor, my last request was filed in a couple of days after the state filed their 109 witnesses. They've listed a fingerprint expert as one of the people that's off the top of my mind. They've listed the co-defendant's parents. The court says that the witness list shall compose of witnesses the state intends to call. Mm-hmm. I would ask the court order the state to reasonably review its 109 witness list. This summer filed a 109 witness list, and the judge in a different matter told me that I needed to go back and realistically reevaluate what shall call is. I think that the witness list is a notice without notice, so to speak, Your Honor, if it's 109 people, one of which is an officer who only participation is effectuating the arrest of Richard Senesi. And so I don't see how he would be relevant.
Okay. So we have the order on the Brady material for an amended or at least reduced to realistic witnesses to be called. Brock, if you can provide me proposed orders on both of those will be due at the final hearing plea deadline on Tuesday.
Thank you, Your Honor.
Judge, I'm sorry. What is it that's going to be due by next Tuesday?
So I'm hearing, Mr. Briggs, that there's one of these just very blanket witness lists that was provided to defense. So I
Right.
need your team to go through and make that a realistic list. For example, if there's several, I mean, I'm pretty sure you're all not calling the co-defendant. And so if you'll go through, well, I don't know. I'll leave that up to you all, but I need you to review that list and make any changes to eliminate, I guess, unnecessary witnesses that are listed there. For
Okay.
example, I mean, the DA, everybody does those lists that just have a ton of folks on there. So,
Right. Well, Judge,
If-
I tend not to do those, and I'm not a big fan of that global witness list kind of thing. I'm at a
Right.
little bit of disadvantage that I don't practice in front of the court very often. And I'm happy to sit down with the team, and we can certainly whittle that down to a realistic
exactly.
number of witnesses. My only concern is that in that is that I've been in plenty of courts where I get hit with the, oh, well, you didn't put them on the witness list, you can't call them kind of thing.
Right.
So, if the as long
Maybe,
as-
maybe,
as long as we're gonna
Mr.
be-
Briggs, maybe we do it this way. Maybe rather than have it be an amended list, maybe create a list of the witnesses that you intend to call.
Okay.
And so there will not be, I guess, a failure of notice in the sense that you've disclosed them, but at least this way we have a good operating list of where we think we're going. Okay.
Judge, I'd love to be able to give, here, realistically, this is who I'm going to call. But, when the defense goes off in some weird direction, starts doing something I hadn't anticipated, I think, it's unfair. I think, the state that now when they've done something unexpected and I tried to give them a nice small witness list of realistic witnesses that then they fight with me being able to call witnesses I hadn't anticipated. So, that's a little bit about why that happens. But if the court wants to whittle it down, we'll whittle it down to the realistic witnesses. I just hope that if something unexpected comes up, there's going to be, a little bit of some understanding about, hey, I tried to keep this list short so it was realistic, but if something comes up, I may need to call someone who wasn't on that list. So
Understood.
Okay.
Understood.
Thank you, Judge.
Your Honor, for the record, I think that's called rebuttal, and I don't think
Yeah.
I don't think that if a witness is not reasonably anticipated, that they get to call the president of the FDIC if they want to go that direction on a rebuttal witness. I don't disagree with that idea.
Okay.
But I understand.
It's just that I've been burned on that in the past, and so
I'm sorry, Mr. Briggs. We'll work on that. All right.
Okay.
What's next? What else? Mr. Benjamin, do you have anything else?
Not off the top of my head, and I apologize. My note list is there. I will, with the court's permission, take it up on Tuesday, Your Honor.
Okay, thank you. Send me the proposed
Two
orders, the other two matters. Is there anything else from the state?
No, Judge, I just wanted to thank the court for giving us a hearing this morning on super short notice, and Mr. Pantoja was awesome in kind of facilitating that. So I just wanted to thank the court and give Chewy a little bit of a public shout out there.
Yeah, true to form. He took
Yes.
care of it. So I'm glad we could accommodate everyone. We'll see you all on Tuesday.
Okay, thank you, Judge.
I second that, Your Honor. May I be excused?
Yes, thank you all.
And may we be excused as well, Your Honor?
Everybody, have a good weekend.